Welcome back. You're tuned in to Power Breakfast here on CNBC-TV18. Now, in what comes as a major setback for the Reserve Bank of India, the Supreme Court has declared the central bank's bad loan resolution framework, which came into effect from February 12, 2018, as unconstitutional. Lata is here with the impact this could have and also the options before the Reserve Bank of India now.
Well, first of all, we must remember that the FEP12 circular asked banks, or rather RBI directed banks, that if borrowers don't pay within a specified period and if they default and you're not able to put a resolution plan, then you have to take it to IBC. Now, if you read the judgment thoroughly, it says that RBI has the power to direct banks to take cases to IBC only with government permission. The rest of the powers of RBI to tell banks to share information on defaulters to the CRILIC database, to tell banks that, you can upgrade a loan from NPA to standard status only if they meet certain criteria. All these other issues are areas on which the court has not commented. In fact, it broadly agrees that the Reserve Bank has power over other issues of regulating banks and protecting defaulters' interest. So actually only a few clauses in the February 12th circular fall foul of what the Supreme Court has written in its judgment. The court has struck down the entire circular, although it has written objections to only one or two clauses in the circular. So my sense is, speaking to the lawyers, that the Reserve Bank has one or two courses. One, it may seek a review whether the circular can stand without those provisions. Alternatively, it may not approach the Supreme Court, but put in another circular not referring to the IBC at all, but still keeping the circular intact. These could be two ways in which the RBI could proceed. A third point which I want to make, and that is who is hurt. The impression is that, the borrowers have won a victory. But if the borrowers have won a victory, then who loses? It is the banks who lose. And that is why Moody's report is very important. Moody's has given the report that this judgment is bank credit negative. Bankers who had the power to arm twist or force borrowers by threatening them IBC resolution get a little weaker. So to that extent, bankers lose, and therefore, if bankers are less powerful than they were before, then depositors also become less powerful. So my sense is that all this will be righted by the Reserve Bank putting in another circular, directing banks to ensure how they handle default cases. In any case, even now, banks have the ability to take defaulting cases to the IBC. It is just that they can't quote the February 12th circular to take them to IBC. But other provisions like one-day default and immediately informing the CRILIC database are very useful parts of the FEP12 circular, and my sense is that the Reserve Bank should frame another circular to ensure that these parts of the February 12th circular are carried forward.
All right, thanks a lot for that, Lata. But we also spoke to SBI Chairman Rajneesh Kumar and also a whole host of other experts on the impact of this judgment. Listen in.
One is that banks had already put a resolution framework under bank-led resolution approach, where that system has already started functioning. Second is that Supreme Court has upheld the constitutional validity of IBC in their previous judgments. So the intent to bring discipline in the lending and borrowing markets, that is not getting diluted in any manner. And that is what, as lenders, or at least I can speak on behalf of the State Bank of India, our approach to the resolution of stressed assets, which is a proactive approach, recognize early the asset and take corrective action. So there will be no change in that. And the discipline which has come in the markets around payment, I don't think that is going to be diluted in any manner.
The Reserve Bank should go before the Supreme Court and ask for clarification about the parts which can still be valid and which part which is not valid. Resolution framework by the Reserve Bank is not an absolute must. Banks are fully empowered to resolve any NPA cases and on their own and they can proceed. The Reserve Bank schemes were required constantly by banks and other interested parties were asking for Reserve Bank to come out with a framework because they wanted some kind of forbearance from Reserve Bank.
The full circular has been held to be ultra-vires. They may not have commented on other things. Now, RBI, to my mind, and we've been talking about it to everyone, what really should come up, and which FM has hinted, the RBI will have to now come up with a resolution process. So this circular had many impractical and harsh conditionalities, and one size fit all. If you recall, SBI chairman himself mentioned that 180 days and 100% conditionality was impractical. So therefore, now this Supreme Court judgment provides an opportunity to RBI to come up with a practical circular.
ASG has made a statement which says that the RBI should have taken into account the stress in the power sector. So the central government clearly is at odds with the RBI when it comes to relief to be given to the power sector. I think there needs to be a revised framework, because depending on how much of the Feb 12 circular survives, given that it derives its powers under 3 different sections, and its powers have been held to be ultra-vires only a specific section. Do the powers under the other 2 sections survive, or they fall away? I think it's a complex legal question. It's not a call which the RBI or the central government can really take. Either we scrap the circular altogether and come out with a fresh circular, or we get clarity from Supreme Court. Till then, I think it's difficult to really say which way the wind is blowing.